recovery of medical costs for asbestos disease in Wales bill?
Lord Mance will explain the decision of the court.
This reference by the Counsel General for Wales concerns the legislative competence of the National Assembly for Wales, the Welsh Assembly, under the Government of Wales Act 2006, which I shall call GOWA. The question is whether the recovery of medical costs for asbestos diseases bill is within such competence. The bill aims to recover costs incurred by the National Health Service in providing services to victims of asbestos-related disease. To that end, Section 2 imposes a new statutory liability on any person who makes a compensation payment to such a victim. The person making such a payment can conveniently be called a compensator. A typical example would be a former employer. The proposed new statutory liability arises from the mere payment, whether the compensator's liability to pay any compensation is established or merely alleged. Section 14 of the bill extends any insurance which the compensator has so as to cover this new statutory liability. The extension exists whenever the compensator has liability insurance, which, to any extent, covers the compensation payment which he makes, or would do so if he were shown to be liable to make it. The policy is then treated as covering the new statutory liability, notwithstanding any terms to the contrary. Under the bill, Welsh ministers must have regard to the desirability of spending an amount equal to the amount received under the bill on research or treatment of asbestos-related diseases. Two main issues arise. First, the bill is only within the Assembly's competence if it, quote, relates to one or more of the subjects listed in Part 1 of Schedule 7 of GOWA, see Section 108(4) of GOWA, or if, quote, it provides for the enforcement of or is otherwise incidental to or consequential on such a provision, see Section 108, subsection 5. The subject in Part 1 of Schedule 7 on which reliance is placed is, quote, organisation and funding of National Health Service. Second, even if the bill satisfies that test, it will still fall outside the Assembly's legislative competence if it is incompatible with the Convention rights scheduled to the Human Rights Act 1998. The bill is challenged on the ground that it has a substantial retrospective effect on the rights of compensators and insurers in relation to conduct which took place and insurances which were underwritten many years or decades ago. And so it is said the bill infringes Article 1 of Protocol 1 of the Convention rights, A1P1, guaranteeing the peaceful enjoyment of possessions. The Supreme Court unanimously concludes that the Welsh Assembly lacks legislative competence to enact the bill. Lord Thomas, with whom Lady Hale agrees, reaches this conclusion on narrower grounds than the majority in the leading judgment given by Lord Mance, with whom Lord Newburger and Lord Hodge agree. It is common ground that the Welsh Assembly has no general fiscal or revenue-raising power, whether to fund the National Health Service or for any other purpose. But Lord Thomas and Lady Hale consider that the concept of, quote, organisation and funding of National Health Service covers not only the allocation of resources, but enables the Assembly legislatively to levy charges on patients. That is quite apart from delegated powers, which are to like effect, which the Welsh ministers have under the NHS Wales Act 2006. The majority of the court leave this point open, but are content to proceed on an assumption that it is correct. Lord Thomas then reasons that because the Welsh Assembly could have levied charges on patients, which the patients could then have sought to recover in tort from compensators such as employers, therefore the Welsh Assembly can impose the new statutory liability directly on such compensators. The majority do not agree. Competence depends, in their view, upon what has been done. It does not depend upon whether a similar result might, if feasible, otherwise have been reached by a quite different route. The effect of the bill is to impose a new form of quasi-tortious statutory liability for economic loss on persons not directly connected with the National Health Service. The bill is outside the Assembly's competence. That is quite apart from the fact that it also imposes a new statutory liability on compensators who may not previously have had any liability to anyone. As to the second point, even if the as to the subsidiary point arising out of the first point, even if the imposition of liability on compensators by Section 2 were within the Assembly's competence under Section 108, subsection 4, all members of the Court agree that the imposition of an extended statutory liability on their liability insurers would not be within its competence under Section 108, 4 or 5. The bill is on that basis alone outside the legislative competence of the Assembly. In these circumstances, the second main issue does not strictly arise, but the minority consider that the retrospective expansion of the insurance renders Section 14 unjustifiably incompatible with A1P1. The majority consider that the bill's retrospective effects make both Sections 2 and 4 unjustifiably incompatible with A1P1. The Supreme Court therefore holds that the bill is outside the legislative competence of the Welsh Assembly.